Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets.
Hi, welcome to Securing Your Brand with Holly McFall and Melissa Jetta from Secure Mark Legal. I'm Matt Sky. Today we'll dive into trademarks, copyrights, and intellectual property. Holly, Melissa, thanks for joining.
Thank you for having us.
Okay, so let's jump right in. Can you tell us what are the main types of intellectual property law and what do they each protect?
There are a few different types of intellectual property. The main ones are patents, trademarks, copyrights, trade dress, and trade secrets. Though trade secret really isn't registered, but it's still intellectual property. Patents are design, utility, a bio or plant patent. They're good for about 15 to 20 years. Then you have trademarks. Trademarks are what protects a business. It protects what identifies a business. The name, the brand, the logo, the slogan, even color or smell can be a trademark. Copyrights are anything that is creative work that you've put in a tangible form. It can't be your idea, but once you've put down that idea into either written it out or wrote out the music or created the art, then you can copyright that. And businesses can have copyrights too. Trade dress is the design. It is what the pattern, the packaging, Coach's pattern on their bag is a trade dress. Apple's layout of their store is a trade dress. And then trade secrets are just that. They're a secret. So long as it's information that is kept a secret, you can then protect that. If someone has infringed on that, you can sue it, but it's not registered anywhere because it's a secret. Those are the main forms of intellectual property.
And what would you say are the key differences between a patent and a trademark?
So pretty simply, the patent protects the design of the invention itself. There's no requirement for it to be for sale or in any business enterprise of any kind. You can come up with your idea that you want to patent and just keep it to yourself once it's registered and do nothing else with it if that's what you want to do. Trademarks, on the other hand, protect a business enterprise, a service or a good that you're selling. It protects the name, brand, logo, etc. for that item once it's for sale.
What's more complex in our current climate, trademark law or patents?
Yeah, it could be. It could be one or the other, depending upon the situation, where an invention or a patent is covered by inventions. That is specifically for an invention. Trademarks are for a business, and a business, anything that identifies the business, whether it is your logo, your name, your brand, we all know and recognize like the Nike swoosh. We all know what that blue box with the white ribbon on. We know that's coming from Tiffany's. We know those are things that we recognize. And so if it recognizes your business, you can trademark that. And really that is protecting your reputation, because what comes from a trademark is, and how your business is identified is really your reputation. What does that mean to your business? So maybe trademarks, because it's really business related, and that's when it gets complicated.
Holly, what are your thoughts?
Yeah, I think I would agree with that. Trademarks, I would say, can be more subjective when the examiner is reviewing them, as far as whether your mark is confusingly similar to another one. That's kind of it's not a black and white standard, where you can say, they attach a number to it where there's like 50% or 60 or 70, it's like it either is or it isn't. And so that can, I think, cause more controversy and more arguments back and forth for that standard. Whereas a patent is a little more cut and dry, either your invention already exists or it doesn't, more of a technical standard, I would say. So yeah, I'd agree that probably trademarks.
Yeah, it makes sense. I could see a lot more gray area in terms of what is or isn't a brand, or an invention is more or less definable. As we jump into patents, can you explain for us the differences between a design patent and a utility patent?
A design patent is it's kind of the look, the design of your invention, where a utility patent is the process, the system, the machinery. That's really the difference between the two of them. They're both registered for 15 years. Remember, once you patent something, it's out there in the public, unlike a trade secret, which you're keeping to yourself. So though a utility patent can cover the same things trade secrets can, you've now put it out there. It's now available to the public, and in 15 years, someone else can use it.
And Holly?
Pretty much same answer. The difference between the two, the design patent protects the design or the look of the invention, and the utility protects the invention itself, the more technical, specifications of how it works and what it is.
So can we get into what kinds of creations are protected by copyright law And what are the limitations of this protection?
Sure. This is a very important part of protections for any business, and often parts of the business that you may not think of. So anything from podcasts like this, presentations, blogs, art would include your logo, any art on packaging of products, your website, mobile application icons, all of these things that really get to the heart of what your business is and identify your business, all of those can be protected by copyright.
And when we get into trade dress, what is that? And can you provide some examples of how it's used in commerce?
Trade dress is the look, the feel, the packaging, the design. Some of the things that people will recognize as trade dress will be like the classic shape of an IHOP building. You know what that looks like if I say it. You can kind of picture it. The outline of a Coca-Cola bottle would be trade dress. But also things like the Coach design, that classic Coach bag, purse design, you know what that is by, once you say it, or the layout of an Apple store is all trade dress. That's all looks the same every time you see it. And trade dress is just another type of trademark. It's for that shape, color, design. It's a trademark registered with the USPTO, and it goes through the same process as a trademark does.
So what happens when you have two companies that have similar shapes and designs and there's a dispute? How is it determined which person gets to continue moving in one direction from a brand perspective or not?
Sometimes it's a race to the courthouse steps. It is a race to register. So it's who's been using it first, who registered it first. And then the opposing party, if they want to say that we've used it or we're currently using it and they're not using it, either has to file an opposition, and that's filed with the U.S. Patent and Trademark Office through what they call the TTAB, the Trademarks Trial Appeals Board, or they do a notice of cancellation and go through that process if one company is opposing another. I mean, you may not start directly in litigation. You may start with a cease and desist and say that was mine first, but that's where you're going to end up.
And how do these trademark disputes happen when, say, a company is violating out in Europe and then there's another business based here in the U.S.? How do you manage those complexities?
So there's a difference in crossing jurisdiction. You're going to have registration with the United States Patent and Trademark Office. There's WIPO, there's European. There's all kinds of different registrations throughout the world. And you can be registered in more than one jurisdiction. It's not unusual for someone to sell like clothing in multiple countries and in the U.S. Most countries have their own trademark or patent office in which it's registered in. You can register through a larger, like WIPO registers more countries in one time, but you can register in Canada, Mexico, United States, wherever you're selling your good. And it has to be something that's used in commerce. Remember, trademarks represent a business. So it has to be used in commerce. You have to be selling in that country to register in that country to say, hey, you're infringing on me in that country.
So it's a very active use protection, I suppose. You can't just claim protection and not actually be selling a product of some kind.
Exactly. You have to be using it in commerce.
What if you're planning on using it, but you haven't released it just yet?
So there you go. That's the next step. There is a gray area. There's most countries, USPTO included, has an intent to use application. You'll have a timeline in which you file that application and then to provide specimens and show that you're using that application. And then you've got to show continued use. You've got to renew your registration. You've got to keep your trademark renewal. It can be good forever so long as you renew it timely.
Gotcha. And Holly, just curious to hear your thoughts on this as well.
Yeah. Well, and so also keep in mind that your protection is limited to your category of your business. So you can't own a name just completely widespread for anything and everything unless you're actually using it for anything and everything. So you apply in your specific class, which is a category, and that's what you would get your registration in. It can expand to what's called a zone of natural expansion. So like a clothing store, it's reasonable to think that they may someday get into jewelry, for example. So if a jewelry store comes and wants the same name as a clothing store, that may still be an issue, even though it's registered specifically only for clothing. So there are definitely, gray areas, but it's important to keep that in mind, that just because you own a name for one thing doesn't mean that nobody else can use it for anything else in the world.
So you hit bigger complexities, I suppose, when, say, a clothing brand does something bold and maybe gets into the tech sector, or maybe they got into selling food or something unusual like that, right?
Right. Then they can file a separate application for that particular class, even though that may not be in that natural zone of expansion. You wouldn't expect necessarily a clothing company to open up a restaurant, but they certainly could if that name is available in the restaurant category.
And what happens with these big retailers who have natural presence in an endless array of markets?
You have the thing like energy drinks, Monster. Monster's got clothing line. They've got energy drinks. They're coming out with an alcoholic drink. They're expanding beyond their category. They've come out with toys and other things that go along those lines. Or think about the car company like Ferrari. It has a restaurant that has a clothing line. They have expanded into many areas. So yeah, you are going to have that where the zone of expansion, the realm of possibilities is going to keep expanding.
Do you recommend brands, and this may not be the case for everyone, but do you recommend them have a very, very distinct name in that way? Are there disadvantages to having a name that could potentially violate trademarks in other industries?
Well, distinct, yes. So the one thing that you very much do not want is a generic name. So, Sally's Nail Salon or, Bob's Best Barbecue, something that is just very generic and exactly explains what you do or what your business is. That's kind of the worst type of trademark. You want something that is distinctive and that doesn't that requires a jump in the logic or in your mental thinking to figure out what that business actually does. So for example, our name's Secure Mark Legal. We've combined two words together, Secure Mark, because we're securing your brand, and trademark. Once you know that we're trademark lawyers, it kind of is obvious, I think, Secure Mark, that we do trademarks, but not everyone would see that obviously as soon as they see our name. We're not the trademark law firm.
Right. And I don't think of you as a fast food company or anything. So
right. Yes.
Yeah. Exactly. Yeah, it's clearly in a certain territory. So mentioning Secure Mark, let's get a little bit into trade secrets. Can you tell us about how they're different from intellectual property protections?
So it's in the name secret, right? So anytime we're registering an IP protection, trademarks, copyrights, patents, we're disclosing to the world what exactly it is that we're doing or trying to protect. A trade secret, you want to keep that secret. So there is no application process for trade secret for that reason. So essentially, when you have something that you have come up with, some new invention or recipe or something like that, you have to make the decision oftentimes whether you want to patent it and put it all out there, exactly what is in that recipe or what is in that invention, or do you want to keep it a trade secret? So for example, Coca-Cola, the recipe for Coca-Cola, that's always been a trade secret. They chose purposely not to file for a patent on that because they don't want people to know what's in it.
Right. I guess once a patent is publicly available, everyone knows basically your formula. Melissa, when is it a good time to conceal or not conceal your formula, so to speak?
Patents have a timeline. They're only good for 15 or 20 years, depending upon the type of patent. And after that time period, we've seen it with pharmaceuticals. You can then have generics. Obviously, Coca-Cola, KFC, the Big Mac sauce, they don't want to have generics out there. They don't want to have someone processing and calling it the same thing. You can have reverse engineering, you can have formula engineering and go through that whole process, and someone can have a copycat, maybe not be the exact same process, same timing, same, formula. But a trade secret is that. You're keeping it a secret, where a patent at some point, it has an expiration date. You're going to get the information in the goods.
One of the big things we think about is, I guess on the trademark side, Disney having lost some of the protections that they had for 100 years. That's pretty significant.
That was under copyrights. Copyrights are only good for the life of the author plus 70 years. So under copyright law, yes, your copyright protection also has a limitation to it. It's a really long, limitation, but it does have an expiration date. And that's what happened to Disney.
So as we jump into the different types, I think we touched on this a little bit, but let's cover it again. So what are the protections offered by copyright law, trademark law, and patent law? And how do they overlap and how do they complement each other?
Okay, so as a review, I guess, trademarks are in connection with a business. You must be selling a good or a service, and the trademark identifies your brand. So that can be your logo, your slogans, the name, of course. Copyright does not have to be in connection with any sort of business. It's simply something that you created that you're asking for protection for. And patents, similarly, not necessarily in connection with a business. They can overlap though. So for example, your logo, it can be trademarked and it can also be copyrighted if there is a level of creativity to that logo. If it's not just simply a letter, or just a word with no creative, you haven't, no design, I guess, aspect to it. As long as there's even a minimal amount of creativity, you can both copyright your logo and you can trademark it.
Right. And Melissa, curious to get your thoughts on that as well.
You need to kind of have an IP portfolio. For a business, you really have to consider what is going to protect your business assets. Intellectual property is a business asset and it has value to your business. It adds value to your business. Your trademarks, your copyrights, your patents, you want to make sure that you're consulting with an attorney, they're looking at the entire portfolio in a whole. They're making sure that you've protected the invention. If you're selling, if you're going to sell that product, they protected the name, the packaging, the color, the logo that goes with it. If you're putting on a podcast, you're putting on a presentation, you're offering workbooks or education, you want to make sure you've copyrighted and protected that asset. It's not only important to stop others from infringing, but it's a business asset. If you're going to leverage your business, you're going to franchise your business, you're going to look for venture capital, they're going to want to make sure that you have your IP all tied up, it's all protected, so that way you've protected your business assets and what they're investing in. So it goes beyond just making sure someone else isn't infringing, or worse, you're not infringing on someone else. It goes through to that this is a business asset that you are protecting your business with.
Right. It's the very foundations of a company itself. Can you discuss a recent legal case or dispute involving intellectual property and the implications it had on the field?
There's a couple of them that have come out recently. I can think of the Kim Kardashian skins that came out that was, in regards to whether or not you could trademark something that was presumably almost generic or descriptive. There's a lot of the case law that comes out in whether or not you're being over infringing. You've got Monster, we talked about it a little bit earlier in the podcast, that they have that realm of expansion and they're really working hard to make sure that they protect their name. And they will litigate anything that is close to or related to one of their brands to make sure that they're protecting it. They're not becoming generic. They're not having someone else infringing on it. Policing your brand and making sure that you are watching your IP portfolio and making sure that someone else is not out there infringing on your brand is always important and always going to be in the news. And, especially when it comes to something big like Kim Kardashian or, another large company, you're going to have people that are trying to infringe and prosper on their coattails.
So regarding copyright law, trademark law, and intellectual property, if you had one takeaway for our listeners, what would that be?
I think it would be that you need to understand the difference between them. We talked very generic as to which one protects what, and that you need to, as you are building your business or you're starting your business, it's never too early to consult with a trademark, patent attorney, or IP attorney in regards to what can be protected, and make sure that you're not only protecting it so someone doesn't infringe on you, but worse, that you're not infringing on somebody else, because it's costly. Protecting your assets and making sure you own them is one of the basic foundations for every business.
I guess I would say just realize the value of IP protections. All of those different things that I mentioned that are part of your business that can be copyrighted, for example. Don't take it for granted that you own those and that no one else can come in and steal them, because they really are the heart of your business. And those are the last things that you would want somebody to take away and try to replicate for their business.
Sounds great. Well, thank you, everybody. This has been Secure Mark Legal. For more information or to connect with Holly McFall or Melissa Jada, please visit securemarklegal.com or find them on social media.
Thank you.
Thank you for having us.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.